Okay, wonderful. I think we can begin. So we're going to do something a little different than last time. We'll do the laws of Edut, of witnesses. There are 22 chapters. The good news is we're not going to finish them all today. Hopefully we try to finish one today. There's a broad range of topics that the laws of witnesses address. And the reason why this is so important is because in the Jewish system in the Torah system of law, I would say almost the only form of evidence is witnesses. And with some exceptions, with few exceptions, you need two witnesses as opposed to one witness. This is something that is actually written explicitly in the Torah. Not something that is derived, but it's written explicitly in the Torah more than once. It says that the matter should be established based on two witnesses, not on one witness. And so with some exceptions, evidence is two witnesses. And there's a fascinating, it's not the most efficient system to need two witnesses to prove everything, because some things there simply were not two witnesses. So I'm not going to say it's the most efficient, but if the idea is to get to the truth, then when you have two witnesses, at least you can find some scientific way or semi-scientific way to get to the truth. So if you go to the court in America and someone testifies, who decides, should the jury decide whether or not the person is trustworthy? Well, whatever makes sense. There's no real rules. There's no real system. Sometimes a person cries and he gets the sympathy. Sometimes a person looks distinguished, so he's believable. But there's no real system of determining whether or not the witnesses are telling the truth. So in the Torah system, the idea is once you have two witnesses, they would separate the two. They would interrogate the one witness, and then bring in the second witness and interrogate the second one. And then you could try to compare whether or not they're saying the truth. And once you do that, you discover that it's not so easy to lie. It's not so easy to conspire to make a lie, because if you have skilled questioners, it's very easy to find a place where the two witnesses have not planned their every detail of the conspiracy, and it's very easy not very easy, but it's at least easy. It's much harder than you think to create a good lie. When we were in the second grade, this is the game we would play by birthday parties. They would send out two witnesses, separate them, send out two witnesses, two kids, tell them to make up a story, and then bring in one at a time and question them. And within a minute or two, you realize that people they were not able to plan every question coming. So the first chapter discusses the various forms of questioning that the judges have to question the witnesses. In other words, somebody comes to testify, what are the critical questions the judge must ask, or the judges must ask? And there are 7. And without these 7 questions, it's not considered testimony. And beyond the 7, there are many more that the judges could ask based on their own creativity or their own intelligence. But the original 7 is the minimum. And we'll see later why these 7 are important. And part of the idea is that you have to pin down the testimony to a specific time and place. And the reason for that is because we'll learn later at the end of the laws, sort of way back, chapter 18, we talk about the conspiring witnesses and how you disprove a conspiring witness. So if I say something happened on Greenwich Avenue at 3:00 yesterday, then there's a way to disprove that if you can prove that it didn't happen on that specific date. But if I just say, I think a few years ago somebody killed somebody, then you can't disprove me, because I did not pin the time down I didn't pin the experience down to a specific time and place. So like the Talmud says, we'll mention it later, if it's a testimony that cannot be disproven, it's not testimony. It's almost like a scientific theory. If it cannot be disproven, it's not science. right? So if it cannot be disproven, it's not a testimony. So the way to disprove it is you have to pin down the specific time and place, and therefore, hence the seven questions that they must ask. That's the second half of chapter 1. Before we get there, we have the first half of chapter 1, which discusses the obligation to testify. It's not a luxury, it's not a right, it's an obligation. If I know that if I know something happened and I'm called, I have an obligation, a moral obligation to show up and testify. If I do not, that's a sin, that's a violation of one of the 613 commandments in the Torah. So this is just an introduction to get us in the mood. I hate to be political, and I shouldn't be doing this so early in the morning. Shouldn't step on landmines. Should I do this? I really shouldn't, but I'll do it anyway. I don't know why. I'm smarter than doing this, but sometimes I just succumb. So I'll do it anyway. So without taking up, the first rule is stay away from controversial issues. Without taking a stand on this specific scenario, which is very difficult for people to do because people are very emotionally involved. But we had the last Supreme Court nomination. There was a controversy whether or not the justice did something all those years ago, and there were testimony. And I'm a Talmudic student, so I don't know what happened or didn't happen, but I just look at it from the lens of the Talmud. Anything that's in the news, I have to look at from the lens of the Talmud. That's where I get my thrill. So what was so interesting to me about that entire episode is that the testimony did not have any of the 7 questions that the Talmud is going to put forth, and Maimonides codifies that you must ask the witness. What day, what year, what time? It was all too vague. And the problem with vague testimony is if it's too vague, then you can't disprove it. If you can't disprove it, it's not testimony. So that's why it's so fascinating to me to read these laws and see how they play out in the real world. Okay, if you're still here and you were not offended by what I said, congratulations. Let's continue studying Torah. You're very brave. Okay. So I'm reading the handout. You don't have to. You can follow. You could follow inside. I said it was in the email, or you could just listen. Whatever works for you. In Maimonides is very organized. So before every section, he quotes the biblical laws that these laws are predicated upon. In fact, when Maimonides set out to write his book of Mishnah Torah that codifies the entire Torah, he first wrote the book of mitzvot, the book of 613 commandments, to make sure he's not missing anything. So first he sent out the book of mitzvot, and then when he wrote the book of law, he began every section with those mitzvot pertaining to them. So it's very interesting because you're going to get 8 mitzvot, which are an overview of all the law, which is really concise form of all the laws of testimony. And these 8 laws that we have in the beginning as the introduction form the biblical basis for the next 22 chapters. So 8 sentences form the biblical basis for 22 chapters. Here we go. I'm just going to read them. So introduction to the laws of Edut. Edut is testimony. These laws contain 8 mitzvot, 3 positive commandments, and 5 negative commandments. They are, I'm just going to list them. 1, for a person who knows testimony to testify in court. So if I know of a testimony, I saw an event, I have to testify. 2, to question and interrogate the witnesses. That's a biblical commandment upon the judges. 3, for a witness who testified in a case involving capital punishment, not to serve as a judge. The witness cannot be a judge. If you've seen something, then even if you know it's true, you saw it, but you can't be open-minded. You cannot be open-minded. Your person doesn't question what they saw. So if a judge cannot be a witness. Okay. 4, not to carry out a judgment based on a testimony of 1 witness, right? We mentioned you need 2 witnesses. There's an explicit verse, not to follow 1 witness in all matters. Of course, there's exceptions, but this is the general rule. 5, not to accept the person who was a transgressor as a witness. This is absolutely fascinating. In America, in our judicial system, the way you prosecute crime, you find a small criminal, you get him to testify against a big criminal, and everything is fine. In the system of the Torah, you can't do that because the small criminal is considered a transgressor, a rasha, a wicked person. A wicked person has no credibility. If he has no credibility, he can't be a witness. So if a person says, well, I've been a mobster for 20 years and now I'm testifying against the boss, they will not accept my testimony because if I'm a mobster, I don't have credibility. Now you ask a question, how then can you prosecute crime if you cannot get the mobster to testify against his boss? That's a wonderful question. Maybe we'll get to it, maybe we won't. But the bottom line is, we're not looking for the most efficient system. We're looking for the most true system. And in some sense, what the Torah is saying is somebody who is wicked, somebody who sins, somebody who is not a moral person, there's no reason to give them credibility. That is number 5. Number 6, not to accept a relative as a witness. And number 7, not to testify falsely. And number 8, to punish an eid zomem. Eid zomem is a conspiring witness, a witness that it has been proven that he testified falsely. That's a eid zomem, a conspiring witness. How do we figure out who's a conspiring witness? That's a wonderful question. Stick around to chapter 20 and you figure it out. And but if somebody who we prove that the person conspired and testified falsely, that person, the mitzvah is to punish an eid zomem in the manner he wished to have the defendant punished. So if I testify that Yankel owes Beryl $100, the penalty is that I have to pay Yankel $100. If I testify that he's liable for lashes, so I get lashes. If I testify that he's liable for capital punishment, then I'm liable for capital punishment. That is the 8 mitzvot that form the basis for everything the oral Torah says about witnesses. So we mentioned the first 8 biblical commandments. Now we get to the elaboration. If anybody wants to comment, wonderful. Otherwise, we go further because, we didn't do that much. We didn't cover much ground. But if anybody has a comment so far, we could take it. Otherwise, we continue. Okay, fine.
Rabbi, just repeat that thing you said about the lashes.
I was saying that anytime if I testify, if witnesses testify falsely against a person, then the penalty, then the commandment is that whatever I try to impose on them is done to the false witness. So if I'm a false witness and I say Yankel owes someone $100, then I pay Yankel $100. If I say Yankel violated a commandment and is liable of lashes, so I get lashes. If I say Yankel murdered and therefore is liable of capital punishment, so I'm liable for capital punishments. So whatever I've imposed, whatever penalty I sought to impose upon someone else with my false testimony is then imposed upon me. That is the 8th mitzvah.
All right, got it. Thank you.
Okay, wonderful.
Well, I just have one comment, Rabbi.
Sure.
But I also don't want to get into controversial territory, but the example, you gave of the modern day application of this is that was not a criminal trial. It was about credibility of the witness.
Correct. So,
right.
Yeah. So again, I'm not telling anybody to evaluate what happened based on the Talmudic criteria, because again, you make an excellent point. The Talmudic criteria is in the code of law. Whether or not you trust somebody, that is absolutely your judgment. And you don't need 2 witnesses to decide who you trust, right? If you have to hire somebody, you make your judgment based on what you know, based on the facts. But what I'm saying is that to me it was interesting that the inability to defend myself against a claim that is not specific. That's all I'm saying. So if you tell me that yesterday at 3 o'clock I killed somebody, okay, fine. Now I could do something. But the moment it's vague, then it can't be defended. So this is just all I'm trying to highlight is you're right. It was not a criminal case. But if it were a criminal case, it would be very hard to defend myself against a vague crime. That is the point I tried to make.
Right.
And so,
Okay,
Rabbi, the concept of a witness here is actually somebody who saw the incident took place. It's
correct.
Not
we'll get to that.
Who is,
we'll get to that. It's not circumstantial evidence. The burden of evidence is very high, at least when it comes to capital crime, and you have to actually see the act, and it's very difficult to get 2 witnesses to see it. And if you're a prosecutor, you're probably unhappy right now because it's not so easy to prosecute crime with the tools laid forth in the Talmud.
So it's not going to be somebody who's a character witness to say the defendant is either a
No.
good person or a bad person.
Oh, well, the only way there's a character witness is not for the defendant. It could be a character witness for the witness. In other words, this is very interesting. The only character witness you need is for the witness. So we mentioned in the fifth mitzvah. Fifth mitzvah was not to accept a person who was a transgressor as a witness. So if I'm coming to testify and I'm the witness and somebody else and two other witnesses come and testify and say that the witness is actually a wicked person, a sinner, however you define that, I'm a mobster, then the witness's testimony is disqualified. You see what I'm saying? So in other words, the character witness is not about the defendant. The defendant, it doesn't matter if the defendant has done other crimes or not. That's irrelevant to this discussion. The only character that's on trial here, ironically, is the character of the witness. Because if the witness is not a upstanding citizen, a person who is believable, then there's no reason to accept his testimony because he doesn't have any credibility.
But if the point of the character witness is to determine if that witness is a transgressor, are we not leading ourselves into a second trial? Wouldn't it be, you're only a transgressor if in fact you have gone through a separate trial for whatever you were accused of and found to have violated that commandment?
Yeah, you may open up a second trial. If I'm a defendant and you show up as a witness, my lawyers will go after your credibility. It happens every day in court. We'll do the same here, right? If I'm a defendant, with all due respect, Andy, I love you like a brother, but if you come to testify against me and I have good lawyers, they're going to go after your credibility, right? I mean, if not, that's malpractice if they don't.
It's that $100 you owe me from the last class.
Okay. There was a joke in yeshiva when you study the laws. It's always Reuven borrows money from Shimon and he pays him back, or he forgets to pay him back. So somebody wrote on one of these WhatsApp messages that go around. He says, "Look, I've been studying Talmud for 10 years. The one thing I learned is someone named Reuven should not borrow money from someone named Shimon." Solved all the problems.
Rabbi,
Okay.
is there, so if there's a penalty for false testimony for the witness, that's equivalent to the penalty for the crime that the person is being tried for, is there a penalty for saying a witness is of poor character? When they're not,
That's a
you know what
good
I'm saying?
question.
False witness.
That's a good question. That's a good question. So I come and I attack the credibility of the witness. So what does that do to my credibility? My credibility is certainly shot. But what happens is, it depends. That's a good question. I have to go back and look. But let's do a simple case. A simple case is I come to testify against somebody. Beth comes and testifies and says that I'm a gangster. So they say, really, what did he do? They say, well, he robbed a bank for $50 million. Okay. So now, in a sense, I'm being accused of having stolen money. So I'm going to have to return that money. If you are found of being accused, if you have found guilty of accusing me falsely of being a mobster and committing that crime, then you would have to take the penalty for that crime. If you see what I'm saying, I'm sorry if I'm getting complicated, right? So let's say I'm testifying against Andy. So Beth comes and says, how could you trust Menachem if Menachem stole $100? Okay, so in addition to attacking my credibility, you're also giving a claim that I stole $100. So now you would have to probably pay back that $100. In addition, once you're known to testify falsely, then you in general you have no credibility, and we discussed this last time. There are great ramifications to that not having credibility. In other words, yeah, there are other ramifications. So the short answer is I guess I don't know, but the short answer is yeah, there will be consequences.
Would this apply to the SOTA situation also?
To the what situation? SOTA situation. Well, the SOTA situation is interesting because the SOTA situation and there is no witnesses. The whole idea is if there's no witnesses, if there are witnesses, then you go by the witnesses. And if the woman has committed adultery, then actually not even adultery. if the woman has been secluded with two witnesses, then there's no sota. The whole sota is in the place where there are no witnesses. So sota is the exception to the rule, I think.
So if the man accused her, there were no witnesses, and can the husband accuse
The
if
whole
there's no?
idea of sota is not an accusation. The whole idea of sota is a suspicion. So in other words, so yes, but they're asking me a different question. What happens if I testify about something and I say that somebody was does something that is it's hard to punish for? So the answer is, we'll get to it. The answer is, I'll confess, I don't remember all 22 chapters, but I'll just give you a case. If somebody testifies that someone else committed adultery, okay, so that's a capital crime in the Torah. You see what I'm saying? So there's always a ramification. We have to just figure out what the ramification is, but hopefully we'll get there. I don't know if I don't know how, we'll see what happens. Look, we don't know what's going to happen to him tomorrow. No one knows what's going to be tomorrow. So we certainly know that we have plenty of Torah to learn. God will give us good health and a lot of peace of mind to continue studying the Torah.
Amen.
Okay, let's jump in. The good news is I don't have my watch. Maybe that's the bad news. I don't know. 25. Okay, 23 after. Okay, fine. So let's start. So we begin with the general introduction. It is a commandment to testify. You can't say, I'm not in the mood. It is a biblical commandment to testify. So I'll read it. I'll try to go as quick as I can so we get to the meat and the potatoes. A witness is commanded to testify in court with regard to all pertinent testimony that he knows. This applies both to testimony that will cause his colleague to be held liable or testimony that will vindicate him. With regard to financial cases, this applies only when he is summoned to testify. So that's an interesting difference. There's criminal court and civil court. In criminal court, if I know that somebody committed a crime, or I know someone is being accused falsely, right? We mentioned that I have an obligation to testify both to incriminate or to vindicate. So if it's criminal court, I have to show up. I have an obligation to show up. I don't have to wait to be subpoenaed. That's a big difference between the American law and the Torah law. The Torah law says you have to show up. If you know something, you have a moral obligation to show up. Not only a moral obligation, but a legal obligation. When it comes to monetary cases, however, I don't have to show up unless I'm called to testify. So that's an interesting distinction. The source of this commandment is Leviticus 5:1, and should he witness, see, or know of the matter, if he does not testify, he will bear his sin. So we know that it's talking. So we see that a person must testify, must show up, and again, if it's a criminal case, he has to show up whether or not he was called. If it's a civil case, he shows up. He only has to come if he's been called. Okay. Now we have the first thing is, so everyone has to come to court. The question is, are there exceptions to the rule? Are there people who don't have to come to court? And the surprising answer is yes, some people don't have to come to court to testify. And we'll see what that means. Why don't they have to come to court? Because there is a concept of, if you come to court, it's not the most, if you're a distinguished person, if you're the king, if you're the high priest, you show up to court. In court, you could be challenged. In court, you're cross-examined. It's not necessarily the most respectable place for a distinguished person. So the discussion is, does everyone have to show up, or is there certain exemptions for people, prominent people, that they don't have to testify? Again, we're not saying there's equality under the law. Anybody could be sued. Anybody could sue, anybody could be sued. But the question is, could everybody be subpoenaed as a witness? And does everybody have an obligation? So we're going to read number 2. If a witness was a wise man of great stature, and the judges of the court did not possess the same degree of wisdom, he may refrain from testifying. The rationale is that it is not becoming to his dignity for him to go testify before them. Hence, the positive commandment of honoring the Torah takes precedence. So we have a collision of two values. We have a value of obligation to testify, and we also have a value of honoring the Torah, honoring the people, the scholar. So the scholar, the commandment to honor the scholar takes precedence. hold your fire. We're not done yet. Hang on, we're not done until we finish this section, and then I'll add a little bit more interpretation, and then we'll open up the floor for questions. When does the above apply with regard to testimony concerning financial matters? With regard to testimony that safeguards a person from a prohibition, by contrast, or testimony in cases involving capital punishment or lashes, he must go and testify. This is derived from Proverbs. There is no wisdom or understanding before God. Implied is that whenever the desecration of God's name is involved, honor is not granted to a master. In other words, once again, just like section 1, just like, I hope people are hearing me. If you're hearing me, shake your head. Okay. Just like in section 1, we made a distinction between financial matters and criminal matters. So when it comes to criminal matters, a person has an obligation to testify, regardless if he has been subpoenaed, as opposed to financial matters. You only have to testify if you've been subpoenaed. That was section 1. In section 2, we see we see another distinction between religious law or criminal law and monetary law. When it comes to monetary law, a distinguished person does not have to go testify. But when it comes to matters of religious law or capital crime, or capital as in criminal court, then you have to go testify no matter how distinguished you are. So I know people are looking at me funny that what does this mean? A distinguished person doesn't have to go testify. So there could be a case, of a lot of money at stake, and because the scholar thinks he's so great, therefore he doesn't have to go testify. So I'm happy to report that although it's not written clearly in Maimonides or in the Talmud, but the Ramah, in other words, the Ashkenazic ruling is basically what you have is as follows. After the generation of Maimonides, a few hundred years later, you have the Code of Law. The Code of Law codifies the law based on a few people, based on Maimonides' code and other codes as well. But the Code of Law primarily follows the Sephardic tradition. Rambam was a Sephardi as well. And on the Code of Law, there are comments of the Code of Law called the comments of the Ramah. Rabbi Moshe Israelish, who was the rabbi in Krakow at the time in the 16th century, and he added comments on the Code of Law, which follows the Sephardic tradition, and he added additions. So one of the additions that the Ramah adds on this concept, and I think Andy will be happy, is that if we're talking about somebody who is distinguished and is too distinguished to come to court on a monetary case, that doesn't mean he doesn't have to testify. All it means is that the court goes to him and will testify. It's like getting what do they call it today? They call it a deposition. You'll go to the other person and they'll gather testimony. I'm not sure Maimonides agrees with that, but at least the Ramah, which is the Ashkenazic tradition, believes that in the case where the distinguished person does not have to go testify, we just means he doesn't have to come to court, but the court will send and collect his testimony. But that is the perspective of the Ramah, which believes that the issue is who has to go to who. I think that there are going to be other opinions who would say no. It's just the process of being interrogated is disrespectful. So it depends on the perspective. If I'm not mistaken, this will be a departure between the Sephardic tradition and the Ashkenazic tradition, because again, it doesn't say explicitly in the Talmud, but the Ramah feels that this is obvious, and therefore he rules that even in the case. So we're talking about a distinguished person in a monetary case does not have to go to the court, but the Ramah says the court has to come to him. Okay, if anybody wants to comment, very good. Otherwise, we go to number 3.
What authority did Maimonides give for claiming that the man of great stature did not need to testify in a financial case?
That's a good question. What are the credentials? Who has to say that you're a distinguished person? So I'll tell you a joke. The joke is that once there was a Hasidic Rebbe who passed away, and one person wanted to be the Rebbe. He wanted to be the follower. He wanted to be the successor. So he shows up to the Hasidim the next morning in the synagogue, and he bangs on the table. He gets everybody's attention and says, "Ladies and gentlemen, I had a dream last night." They say, "Really? What was your dream?" He said, "My dream was that the previous Rebbe came to me in a dream and told me that I should be the next Rebbe. So they said, really? They said, well, yeah, but it doesn't work that way. What has to happen is the Hasidim have to have the dream, not you. In other words, yeah, so that's the question. Do I self-declare as a prominent person? The Maimonides is not going to say what the credentials are, who has to decide, because there's no way to determine it. We're talking about a scenario where everybody agrees. The court itself agrees that this person is distinguished, right? So the question is not, we have a dispute whether this person is a great scholar. Everyone he agrees he's a great scholar. The question is, should a great scholar have to come?
My question was a little bit different. You cited a difference between the Sephardic and Ashkenazi views about testifying. And reading, at least on Chabad.org, I wonder what Maimonides' authority was for saying that the scholar does not.
My guess is that the question should be for the Ashkenazim. In other words, Maimonides is much closer to the Talmud. The Talmud says he doesn't have to testify, period. He doesn't have to testify. That's what Maimonides says. We assume that means he doesn't have to come to court, and he doesn't have to subject himself to a deposition. But the Ramah is inserting interpretation in the Talmud. He's saying, look, when the Talmud says you don't have to come testify, it doesn't mean you don't have to testify at all. So the question, I think, is more on the Ramah. The Maimonides is much closer to the simple reading of the Talmud. But Ashkenazim are never afraid to say that the Talmud, you don't have to follow the simple reading. You have to go the deeper meaning. So in other words, I think that this is it's a difference in analysis of the perspective of the Talmud. Again, how do you read the Talmud? When the Talmud says you don't have to testify, is that a blanket statement that testimony is not necessary? Or does it just mean that you don't have to show up? So but I would say that I think the simple reading of the Talmud, I'll be honest with you, I'll make a confession, okay? You ready? I've studied the Talmud, Tractate Sanhedrin, I've studied the Maimonides tens of times. Only this morning did I discover that the Ramah says that you have to show up. I've never known that, because that's the simple reading of the Talmud is you don't have to testify. I wouldn't even think otherwise. But then if you're thinking about it before you say it, you think about it and say, well, that's strange. So maybe there are other opinions. Oh, sure enough, the Ramah believes that you don't have to go testify if you're a prominent person and it's monetary law, but they would come to you and collect testimony from you. So if anybody doesn't like the ruling of Maimonides, you can, especially if you're an Ashkenazic Jew, you can fall back on the Ramah and rest assured, and you'll be able to sleep tonight. Okay, so where are we at?
Question.
Go ahead.
All right. This is the Ashkenazic interpretation you just gave is fine. What happens if it's a Sephardic court, but the person is Ashkenazic? That's a serious problem.
Sorry
to bother you.
That's a serious problem. I don't know. The judges do whatever they want, probably.
But does the Ashkenazi have to observe by it? Because say, wait a minute, my background
That's
says,
a good question. I don't want to address it now. I'll just give one general statement that says as follows. The Sephardim believe, so the Talmud says, if the law is not clear, then the Talmud says, in the land of Rav, you follow Rav, in the city of Rav, you follow Rav, in the city of Shmuel, you follow Shmuel. So it depends where you are. So if you're in Sfarad, if you're in Spain, you have to follow the Sephardic law. Okay, that was clear for hundreds, thousands of years. The problem is that once you get to the modern era, the same town has both the Sephardic and Ashkenazic shul, or everything is intermingled. There's no Sephardic lands and Ashkenazic lands anymore. So therefore, every community, you follow your ancestors. Okay, so here is a serious, I don't want to say if it's a joke, it's a serious matter. The Sephardim believe that if you go to Israel, then Israel is the land, because who operated in Israel? The Beis Yosef, the author of the Code of Law, and he was a Sephardi. So they believe that in Israel, for hundreds of years, they follow the laws of the ruling of the Sephardic tradition. So they believe that Israel, the entirety of Israel, is Sephardic territory. And if you're going to show up to Israel from Eastern Europe, you better follow the Sephardic ruling. That's what the Sephardim believe. This is Avad Yosef, other great Sephardic leaders believe that. And it's wonderful. The only problem is the Ashkenazim don't agree.
So if you have a good Ashkenazic lawyer, and he says, wait a minute, there's prejudice here because it's a Sephardic court against my client, who's Ashkenazic, the good Sephardic lawyer, I mean, a good Ashkenazic lawyer might
Yes,
be,
yes.
you know.
Yeah, that's a good question. So that's a good question. But I just brought this anecdote. It's not an anecdote, it's a real thing to figure out that's a serious question. But typically the court you're going to go to is going to decide. And so that's a broader discussion of Ashkenazic law and Sephardic law. Maybe next year, Shavuos, if there's no corona, we'll talk about it.
Okay, talk about it then.
Okay, but I couldn't resist because that was so funny. And it's just so beautiful to me that the Sephardim believe Israel is Sephardic territory, and they believe that all the Ashkenazim have to follow Sephardic law in Israel, and it's wonderful. But the Ashkenazim disagree. Okay, fine.
Thank you.
Thank you. Next, one more exception to the obligation to testify. We discussed the distinguished person. Now we look at somebody else who's very distinguished, not distinguished based on their wisdom of the Torah, but distinguished based on their position in the community, and that is the high priest. So it's one person, the high priest. Here we go. A high priest is not obligated to testify. An exception is made only with regard to matters involving a king. In such an instance, he should go to the high court and testify. With regard to other testimony, he is not obligated. So in other words, I think what's happening here, I may be wrong, that, I think that, okay, it's not so clear. Okay, it's not clear what's happening here. What are we talking about? It says the high priest does not have to go. The question is, what are we talking about? Are we talking about only monetary law or also criminal law, criminal court? It's not clear. Maimonides is quiet. The commentaries the commentaries that discuss Maimonides are not clear what Rambam says. So one way to read this is that the high priest is not obligated to testify at all. Another, unless it pertains to a king, because if it pertains to a king, then I guess the king is more prominent than the high priest, and therefore the high priest would have to go and testify for the king. But it's not clear whether or not we're referring to criminal law or just monetary law, because in the previous section it said clearly when it talked about when we spoke about a Torah scholar, we said that the exemption is only for monetary cases, not criminal cases. And Maimonides is quiet in number 3 when we talk about a high priest. So hence the debate whether it was the exemption of the high priest as it applies specifically to monetary law or to all matters of law as well. So these are the first 3 sections. Now we established a mitzvah to testify with the exceptions. Now we move to what is the heart of the testimony, and that's what I alluded to earlier. What are the 7 critical questions that without those questions there is no testimony? And that's what we're going to get to right now if we have time. But it's interesting just to see this is the style of Maimonides. The first thing, he sets out the law. Then the exceptions. Now, if you're studying Talmud, the exceptions can be dispersed around the entire Talmud. But thank God for Maimonides. Maimonides codifies this, and therefore it's organized, and therefore our head does not have to spin, or at least it doesn't have to spin as much as it would when we study Talmud. Okay. Beautiful. Beautiful. Wonderful. Okay. So that is number 3. Now we get to the heart of the matter of what is the definition of testimony. We have 5 minutes left, so at least we'll start. We'll read number 4 as well. And again, the point is you have to pin down this testimony. And like I said, we're going to separate the 2, ask each witness separately, and then compare their answers. So I must say that the purpose of these questions is not to see whether these 2 witnesses are lying, because it's very easy to conspire and answer 7 questions. The way we try to get to test the veracity of the words of the witnesses is by adding additional questions that they will not anticipate. But I think the purpose of these questions is, again, I think, in my opinion, it's to pin down the testimony to a specific place, because if you don't have a specific place, it cannot be, or time, it can't be disproved. If it cannot be disproved, it cannot be proven. So again, testimony is something that could be disproven. That's the risk the witness takes That's the idea. If a false witness could say something without pinning himself down and without exposing himself to be disproved, then we have no reason to accept it. So if I want to testify that somebody killed someone, I'm running the risk that if I want to testify falsely, I'm running a reasonable risk that someone's going to find out that it's not true and I will be killed. But the only time I'm running a reasonable risk is if I pin down the testimony. If I say it happened at a specific time and place. If I say it happened over the decades when I was a teenager, okay, it's very hard to disprove because how are you going to prove that it didn't happen? As opposed to if I have a specific time and place and date, then it's much easier to disprove, and therefore the false witness is running a risk, and therefore we give him a little bit of credibility, at least the potential of credibility. At least we go and test and investigate the case. Here we go. I'm going to try to read the entirety of 4, and after that we'll open up the floor, and after that we'll send you on your day. Okay. It is a positive commandment to question the witness and to interrogate, to witness the witness and to interrogate them, asking many questions and weighing their replies exactingly. They should divert their attention from one matter to another while questioning them, right? So it's like if you're a good trial attorney, you know this all the time. You talk about A and then you jump to B and you jump back to C. You keep jumping all around to try to confuse them. So that they will. So what's the point of questioning them? So that they will refrain from speaking or retract their testimony if there appears to be flaws in it, as Deuteronomy 13:15 states. And you shall inquire and research thoroughly. That's the biblical commandment. The judges must show extreme care with questioning the witnesses, lest from their questions the witnesses learn to lie. They ask them 7 questions. In other words, when you're asking questions, there's leading questions. In other words, you can ask a question, you can phrase a question in a way that will tip off the witness what you want him to say. So you have to be very careful, if you're the judge, to ask questions, but not to lead them into a specific direction. Now, they ask them 7 questions. What are the 7 questions that are the foundation of any testimony? In which 7-year cycle the event occurred, right? In biblical Israel, time was the year. You have to know the year, but before the year, which Shemitah, which 7-year cycle? And then B, in which year? C, in which month? And D, on which day of the month? E, on which day of the week? F, at what time? G, in what place? So we have, most of them are time. So we have 7-year cycle, what year, what month, what day of the week, what time. And then, so there's 6 questions about the time, and 1 question about the place, in which place. These are the 7 testimony, 7 questions. If I say it happened somewhere in the Northeast, it's not testimony. Why is it not testimony? Because it cannot be disproved. If it cannot be disproved, it's not testimony. Okay, now, even if a witness says he killed him today, or he killed him yesterday, we ask him all the above questions, right? I come into court, I say it happened yesterday. It doesn't matter what yesterday. Pin down, say the time, say the space, what day, what year, be clear about it. In addition to these 7 questions, which are asked universally, the judges inquire into the fundamental issues involved. For example, if the witnesses testify that a person worshipped false deities, the judges ask them, which deity did he worship? Which deity did he worship? What type of idol? What service did he perform? If they testified that he desecrated the Shabbat, the judges ask them, which forbidden labor did he perform? And did he perform it? How did he perform it? If they testify that he ate on Yom Kippur, the judges ask them, which food did he eat? How much did he eat? If they testify that he killed someone, the judges ask them, with what did he kill him? Inquiries of this type are considered as fundamental questions, chakirot. In other words, we're going to distinguish in this section, we get to, in number 5, we're going to distinguish between questions that are essential, fundamental questions, he calls them, chakirot, and then there's just other questions that are not directly connected. For example, what color pants was the guy wearing? That's considered an additional question. So we have the critical questions, the fundamental questions are the 7 questions that pin down the time and place. And in addition to that, we also want to know what happened, right? We know when, we know where, but then what? We have the 5 W's. The what happened? What did he do? How did he do it? And we're going to see those are the fundamental questions. And then hopefully next time we meet, you know what? Maybe we'll finish the chapter. How is that? We'll go a little overtime. we'll finish the chapter. We'll be brave, and then when we come back next time, we'll do chapter 2. Okay. So I'm going to go a little express train, a Sella. So if you have any questions, write them down, and then we'll talk about it when we finish. The Derishot and Chakirot. Chakirot is the fundamental questions that we mentioned. I'm in 5. Involve the matters that constitute the essence of the testimony. On their basis, the person will either be held liable or released. They include defining the deed that was performed, the time when it was performed, and the place where it was performed. On these basis, the testify of the witnesses will or will not be refuted through hazama, the testimony it should be. I mean, this is the point I made earlier. Only when you answer these 7 questions could you become a zomem, could you become a conspiring witness, could you be disproved. And that's why these questions are so important, because they subject the witness to the possibility of being disproved. For we cannot refute the testimony of witnesses unless they define the time and place of the deed involved. That's 5. One more, section 6, and then we're done, the first chapter. In addition, the judges question the witnesses exceedingly with regard to matters that do not involve the fundamental aspects of the testimony, and their testimony is not dependent on them. So in other words, we ask all different questions that are not fundamental. These questions are called bedikot. Literally, bedikot means to check. A chakira means an investigation, and a bedika means to check. So we use the term chakira, investigation, about the matters that are critical, and then we use the term checking for all other matters. The more a judge questions the witnesses with bedikot, which means the uncritical questions, the more praiseworthy it is. So the better judge you are. What's a good judge? A good judge is someone who knows how to ask a lot of good questions, even questions that are not directly connected to the fundamental questions mentioned earlier. What are examples of bedikot? Witnesses testify that a person killed a colleague. So somebody comes in and says somebody killed. The witnesses were questioned with the 7 chakirot, which we mentioned, which define the time and the place and the act. Okay, so somebody comes in and says, someone murdered. We ask the 7 fundamental questions, and we also ask them to define what happens. Similarly, or I would say additionally, they are interrogated with regard to the deed, and they define the deed and the murder weapon. Okay, the murder weapon is something critical. It's not additional. It's part of the fundamental questions. The judges continue to interrogate him. They ask, what was the murderer and the victim wearing? White clothes or black clothes? Was the earth where he was killed white or red? These are similar questions, are called bedikot, right? The color of the sand where the crime happened. It's not critical to the case. In other words, it's not critical to the testimony. The testimony is when, where, and what, and how. But to know the peripheral situation, that's not critical. But a good judge will ask that as well. And remember, we'll see later, if they contradict each other, the whole testimony falls apart. We'll read about that in chapter 2. One more short paragraph. An incident, we'll bring an example of a story recorded in the Talmud. An incident once occurred when witnesses stated that a murder took place under a fig tree. Okay, so we know the place. It was under a fig tree. The judges questioned the witness. Were the figs black or white? Were the stems long or short? Right? I don't know. It's not critical to the murder case whether or not these figs had a long stem or a short stem, but that's a good judge. The more a judge questions the witnesses with bedikot like these, again, bedikot means checking, the more praiseworthy it is. Ladies and gentlemen, give yourself a round of applause. You concluded the first chapter of Maimonides, the laws of Edut, the laws of testimony. You only have 21 chapters left, but it's a good beginning, a good chapter. So thank you for joining me in this journey. If anybody wants to ask any questions, now is the time. Otherwise,